Around midnight, I learned my lawyer billed $20,000 on $100,000 trust, then quit 2 weeks before sanctions court. I called her. No answer. I checked the docket. New orders I hadn't seen. My stomach dropped hard, you know. I mean, what was I supposed to do? And here's where it gets worse. The court had ordered her to submit invoices within 10 days. The docket timestamp showed May 21st. Nothing uploaded. I opened my email thread. Her promise was right there. She'd submit without redactions. Then another email months later, refusing. Document proof in black and white. 23 billing entries for trust drafting. Redactions threatened for communications. The clerk's note. Failure to file could impact fee review. By then I was shaking. I took screenshots. I lined them up. Then I called the probate clerk. She picked up on the second ring. Sir, there are multiple orders outstanding. Her voice went flat. An annual guardianship report was due 30 days ago. I gripped the counter. No one told me, she exhaled. We sent it to counsel. We mailed you a courtesy copy. I never got a call. My throat tightened. Can I file it myself? It must go through your attorney. Her tone softened. If she's moving to withdraw, you'll need new counsel or the court's permission to file pro se. So I'm late because my lawyer went silent. Heat rose in my chest. And now I'm facing sanctions? The judge will sort it out, she said. At the next hearing, the judge didn't blink. The fees here sound excessive, she leaned forward. Her tie was deep green, same one from yesterday. Submit invoices unredacted to chambers in 10 days. I nodded. Yes, Your Honor. My lawyer smiled too wide. Of course. She tugged her sleeve. We'll comply. After in the hallway, I asked. You'll send them unredacted, right? My voice shook. Her jaw tensed. I'll review for privilege. That's not what you told the court. I held up her email. You agreed. She looked past me. I'll handle it. I wondered if she ever would. 3 weeks passed. Nothing came in. I emailed again. Then again, silence. I lost my job the same week. You know that feeling when your chest feels hollow and you can't sit still. That. I asked her if she'd filed the invoices. I asked her if she'd seen the judge's orders. I asked for a plan. 81 days ticked by. When she finally responded, it was one line. It would be unprofessional and illegal to submit unredacted invoices. Her tone went cold through the screen. We will not do that. So what changed since May? I typed with numb hands. What statute? What rule of conduct? No answer. Another order hit the docket. The opposing side moved for sanctions and contempt. A hearing set for 2 weeks out. I grabbed my car keys. I drove to the courthouse because waiting felt worse than moving. I asked for a copy of everything. The clerk glanced at the screen. You missed the guardianship report. Deadline. I tried to file, I blurted, and they told me it had to go through counsel. She looked tired. You have to pick one path, represented or not. I don't even know if I'm represented. My hands went cold. She stopped answering. File a motion to substitute counsel, or to go pro se, she offered. I don't know how. The words came out small. Help center is down the hall, she replied. I stepped aside and dialed 3 numbers. A new attorney answered on the 4th ring. I laid it out fast. Sanctions hearing in 2 weeks. Lawyer just moved to withdraw. Trust is for a disabled relative. Judge flagged fees. You have the invoices? Her voice stayed even. I have promises, no invoices. I swallowed. I need help. I'll review, she replied. Send me everything tonight. I jogged to my car. Now, I know what you're thinking. I could hear you asking why I didn't fire the first lawyer months ago. I kept hoping she'd fix it. I kept believing the next email would land. That's how you get burned, right? I scanned the orders at my kitchen table. I highlighted deadlines in yellow. The guardianship report. The trust draft edits. The fee submission. The contempt motion. The sanction request. Listed 6 failures across 4 months. Frequency stated clearly. 3 missed responses. 2 ignored directives. 1 late annual filing. At this point, I'm done. I sent the new lawyer a folder with everything. Her reply came back fast. I need the retainer. Also, draft a declaration tonight. My leg bounced under the table. I lost my job on Friday, I wrote. I can't cover a big retainer. She didn't flinch. We'll limit scope, get past sanctions first, then decide. The next morning, the judge's assistant called me. I gripped the phone tighter. The judge wants the invoices or a statement, she said. Counts must be exact, dates too. My lawyer refuses. My jaw clenched. What happens now? The court can order disgorgement, she responded, or referral to discipline. My heart raced. What about me? Non-compliance risks contempt, she answered. The risk finally hit. If I missed one more thing, I could lose guardianship. I could lose control of the trust entirely. The stakes weren't abstract anymore. They were crystal. The judge had already set a review. She could appoint a public fiduciary. She could freeze distributions. She could fine me. She could jail me for contempt if it got bad enough. At the courthouse cafe, I rehearsed what I'd say at the hearing. Then my phone buzzed again. An email from the first lawyer's assistant dropped in. Attached is the I-9. I stared at it. I'd already applied. The number matched what I had. The assistant added one line. Counsel will withdraw. My hands they started shaking. I met the new lawyer at her office that afternoon. She closed the door and set a thin file between us on the table. We need a timeline that survives cross. I pushed my folder over and started talking. She took notes. Fast, precise, zero fluff. Now, I know what you're thinking. Her pen paused. Should you tell the judge about the job? Yes, because it explains hardship, not neglect. My shoulders dropped. Air finally moved again. She flipped the file and pointed to a blank form. Draft your declaration tonight. Facts, dates, attachment list. I opened my laptop and built a table. Date, order, response, failure, reason, fix, and bring proof you chased counsel. I pulled up emails, screenshots, voicemail logs. Good. We moved to continue sanctions and compel invoices. What if the judge refuses? She leaned back. Then we narrow harm and show good cause. The plan steadied my breathing. But here's where it gets crazy. At 5, opposing counsel emailed a proposed order freezing distributions. I forwarded it to new counsel with shaking hands. She replied one line. We fight that first. Call the bank, confirm no disbursements, get a letter. I dialed the branch manager and explained the situation. Account still unopened pending IN, right? He checked and confirmed nothing existed yet. I got him to email a verification letter immediately. That night, I built the timeline till midnight. Coffee stains marked the page. I stapled exhibits in piles by issue. I rehearsed answers out loud to empty air. Why late? Counsel abandoned me midstream. Why not fire earlier? I kept trusting her assurances. Morning came fast. I ironed a shirt. In court, the calendar was packed. When our case was called, my pulse thumped. The judge scanned the file and looked up. Counsel, your motion to withdraw is first. My old lawyer stepped forward, voice cool. Irreconcilable differences, client communication breakdown. The judge tilted her head, invoices. Old counsel folded her hands. I must redact privilege descriptions. Privilege covers content, not totals and dates. Her mouth tightened. I disagree, Your Honor. The judge leaned forward, eyes steady. Submit unredacted invoices in camera by 5 today. Failure will trigger an order to show cause. Old counsel slumped a fraction. No one breathed for a beat. Then the judge turned to me. Sanctions motion next. Why no guardianship report? My voice came rough. I kept calling counsel. I tried filing Pro C. Blocked. Court can review my call logs. Opposing counsel stepped in immediately. Your Honor, pattern of neglect. Deadlines ignored. Trust at risk. The words stung. My legs started bouncing. My new lawyer rose, calm but firm. We entered limited appearance this morning. Client had counsel silence. Good cause exists. We need 30 days. Opposing counsel shook his head. Every day harms the beneficiary. Freeze assets. Appoint a conservator. My throat burned. No distributions happened. Accounts not open, the judge motioned. Proof. I handed up the bank letter. She studied it for a long beat. All right, no freeze today, but accounting is required. You will file within 7 days verified. Heat prickled across my neck. We can do 7, my lawyer said carefully. The judge nodded. Next. Fees. Court wants numbers. Old counsel cleared her throat. There is a charging lien protecting my firm. The room went tight. Amount. The judge's tone cooled. 20,000 through August, plus a balance pending. My jaw locked, I whispered. On 100,000 trust. Opposing counsel lifted his eyebrows. The trust cannot absorb that. Remove him. Appoint neutral. My lawyer stepped closer to the lectern. Court flagged excess. Disgorgement belongs on the table. We request escrow of disputed fees. Old counsel pressed her lips together. We object, privilege, work product, ethics rules. The judge wrote notes, slow and deliberate. Invoices by 5. Declaration on why redaction is required. Sanctions held in abeyance pending that production. Relief flickered in my chest. Then she kept going. Guardianship, compliance is separate. File the annual report within 10 days or show cause. I nodded fast. Yes, I can do that. Opposing counsel pivoted hard. Your Honor, he lost his job. He lacks capacity to administer. My chest tightened. My lawyer straightened. Job loss equals hardship, not incapacity. Caretaking remained stable. No distributions were mishandled. The judge looked back at me. Can you meet these next deadlines? Yes, with counsel's help, yes. She tapped her pen, then ruled. Motion to withdraw granted. Limited appearance allowed. Accounting in 7 days, guardianship report in 10. Invoices to chambers today by 5. We stepped away from the bench together. Opposing counsel drifted near, voice smooth. If you miss again, I move to remove you. I met his eyes. I will not miss. He smiled thinly and walked off. My new lawyer leaned close. We sprint now. You gather records. I draft motions. And watch for the invoices drop. I spent the afternoon scanning receipts and bank statements. I built a binder for the accounting. I recorded hours. I spent caregiving. Then my email pinged. The subject line read invoice submission. I opened the attachment and froze. Redacted blocks covered nearly every description. Totals showed 20,000 through August. Another page listed projected fees pending review. My chest buzzed and my hands cramped. I forwarded it to counsel with 3 words. This is almost useless. She called immediately. Her voice stayed level. Totals and dates are enough for now. We still move to disgorge later. Meanwhile, focus the accounting. And draft your guardianship report tonight. I typed until 2 in the morning. I listed medical appointments, equipment, transport, meals. I described routines and ongoing needs. My eyes burned, but the forms were done. Morning, new counsel filed everything by e-file. Then, a new notice hit. Emergency review at 3. Opposing counsel alleged dissipation and demanded removal. I called my lawyer. What now? She didn't hesitate. We walk in with proof. Bring receipts, bring logs, bring that bank letter. I'll handle the removal argument. At 2:40, we were back before the judge. The bailiff opened the door and called our case. We walked up together, and my chest tightened under the rope stare. The judge glanced at the emergency motion. Then she looked at me. Why an emergency? Opposing counsel smoothed his tie. Dissipation risk, Your Honor. Pattern of delay, non-compliance, unclear expenditures. My lawyer stepped to the lectern. Her voice stayed steady. No account exists. No distributions were made. We submitted a verified accounting. The judge lifted the bank letter. I see that. She turned to opposing counsel. Specifics. He tapped a page. Transportation reimbursements without receipts. I raised a binder. Receipts are tabbed. Mileage logs. Pharmacy runs. Hand them up, the judge instructed. I passed the stack. My fingers trembled as paper slid. She read in silence, eyes tracking each line. The room went very quiet. All right, she said finally. Removal is denied without prejudice. Opposing counsel started to protest. She lifted a hand. He cured the lapse. He filed the accounting. No distributions occurred. He tried again, but the guardianship report was late. She nodded once. He will file within the deadline I set. Her gaze sharpened. Missed again, and I revisit removal. That landed hard. I nodded fast. Yes, Your Honor. The judge shifted. Now, fees. She glanced toward the back. Former counsel present? A voice from the gallery. Yes, Your Honor. Invoices by 5 were required. The judge waited. Were they delivered unredacted to chambers? The answer came hesitant. We submitted with redactions to protect privilege. Heat climbed my neck. My lawyer spoke before I could. Privilege does not bar time entries and totals. Descriptions can be tailored, not blacked out. The judge's jaw tightened. Counsel, produce unredacted invoices to chambers by 10 tomorrow morning. If confidential, mark them for in-camera only. She paused. Fail, and you will appear on an order to show cause. The gallery stilled. The message was plain. Then, the judge turned to me. You will not pay disputed amounts until further order. I exhaled. My shoulders dropped. Opposing counsel shifted tactics. Then appoint a neutral auditor. He gestured to his motion. Fees threaten the corpus. My lawyer nodded. We welcome a fee auditor with a cap paid from counsel's share. The judge wrote for a long moment. Motion, granted in part. The court will appoint a fee examiner. Interim cap is set at $10,000 from counsel's retained funds. The gavel tapped once. Anything else on the emergency? Opposing counsel tried one last angle. Freeze all spending. The judge shook her head. No freeze. All expenditures require contemporaneous logs. Any large expense needs prior approval. She looked at me. Do not guess. Ask. Yes, Your Honor. My voice came quiet. She dismissed us with dates. Status in 4 weeks. Fee hearing in 6. We stepped outside. My hands finally stopped shaking. My lawyer glanced over. We bought time. Now we build the fee case. I rubbed my forehead. Do I also file a grievance? Separate issue, she answered. Document everything. We will start with fee arbitration. If that fails, then grievance. For now, meet the guardian deadline. I got home and opened a thick envelope from Chambers. The envelope was already open. A clerk's letter summarized the orders in plain language. Deadlines. Hearing dates. Fee examiner appointment pending. It felt like a map I could follow. I brewed coffee and started the guardianship report. I listed appointments, medication management, home modifications, daily routines, emergency contacts. I printed mileage logs and taped receipts to sheets. My jaw clenched from clamping my teeth. At noon, I drove the packet to my lawyer. She reviewed every page, marking tiny notes. This reads strong. She looked up. Get a letter from the primary doctor. I nodded and reached for my phone. The doctor's nurse picked up. I explained the court needed confirmation of needs. She put me on hold, then returned. We can print a summary today. Pick up after 3. Thank you. My voice came out low. I appreciate it. On the way, my phone buzzed. An email from former counsel. Invoices will not be unredacted for any purpose. My stomach twisted. I forwarded it to my lawyer. She called me while I drove. We will file a notice to Chambers. Bring your phone when you get here. The judge will want the refusal on the record. I parked, walked in, grabbed the doctor's summary, and drove straight to her office. She read the email twice. All right, she murmured. We move for an order to show cause now, and ask for partial disgorgement immediately. She typed fast. I signed declarations again. Then we filed. Next morning, we were back in court. The judge looked at former counsel. Are you refusing a lawful order? Former counsel stood rigid. I cannot ethically file unredacted descriptions. The judge's voice cooled. You will comply in camera. I am not asking for public filing. Silence stretched. Then a small nod. By noon, the judge concluded. And you will deposit $10,000 into the registry pending review. The tiniest win hit my chest like air. The judge turned to me again. Your guardianship report? My lawyer passed it up. The judge read. Compliant. Acceptable. She set it aside. Now, on accounting. We handed receipts and logs. Opposing counsel skimmed, then pivoted. Your Honor, the trust language. We need clarity on legal fee coverage. My lawyer was ready. We propose a cap in prior approval over thresholds. Fees for administration only, litigation only with leave. The judge nodded. Submit a joint draft in 14 days. Any dispute will be resolved at the next status. We walked out lighter. The fee examiner's appointment order arrived that afternoon. A retired probate judge. Review scope defined. Timeline was 4 weeks. My lawyer grinned for the first time. He is no nonsense. If time entries are fluff, he will slice them. My leg finally stopped bouncing. Then, a curveball. Former counsel emailed a partial set of invoices with minimal descriptions. Totals matched roughly.